5 seconds to go. Start. In absence of any evidence on record adduced by the respondent disputing the evidence adduced by the appellant, the family court could not have passed the order believing the oral submissions of the learned counsel for the respondent. She had clearly stated as to how she was harassed and subjected to cruelty by the respondent, which had constrained her to leave the matrimonial home along with her children, and as to how the respondent had failed and neglected to maintain her and her children. She had also proved by producing the documentary evidence that her father had paid money to the respondent from time to time to help the respondent for his business. Even if the allegations of demand of dowry by the respondent were not believed, there was enough evidence to believe that money was being paid to the respondent by the father of the appellant wife, which substantiated her allegation that the respondent was demanding money from her father and was subjecting her to harassment. The errant respondent had also gone to the extent of questioning her chastity, alleging that Rajit was not his biological son. There was nothing on record to substantiate his such baseless allegations. His application for DNA test was also rejected by the family court. Of course, the family court granting the maintenance petition so far as the appellant number 2 son was concerned nonetheless had thoroughly misdirected itself by not granting the maintenance to the appellant wife. Such an erroneous and perverse order of family court was unfortunately confirmed by the High Court by passing a very perfunctory impugned order. The High Court, without assigning any reasons, passed the impugned order in a very casual manner. This court would have remanded the matter back to the High Court for considering it afresh. However, considering the fact that the matter has been pending before this court since the last 4 years and remanding it back would further delay the proceedings, this court deemed it proper to pass this order, though it was sought to be submitted by the learned counsel for the respondent and by the respondent himself that he has no source of income as his party business has now been closed. The court is neither impressed by nor is ready to accept such submissions. The respondent being an able bodied, he is obliged to earn by legitimate means and maintain his wife and the minor child. Having regard to the evidence of the appellant wife before the family court and having regard to the other evidence on the court, the court has no hesitation in holding that though the respondent had sufficient source of income and was able bodied, had failed and neglected to maintain the appellants. Considering the totality of facts and circumstances, we deem it proper to grant maintenance allowance of rupees 10,000 per month to the appellant wife over and above the maintenance allowance of rupees 6,000 granted by the family court to the appellant number 2 son. It is accordingly directed that the respondent shall pay maintenance amount of rupees 10,000 per month to the appellant wife from the date of filing of her maintenance petition before the family court. The entire amount of arrears shall be deposited by the respondent in the family court within 8 weeks from today, after adjusting the amount, if any, already paid or deposited by him. The appeal stands allowed accordingly. Stop.